name is John Gastil. I'm at the Pennsylvania State University in University Park, Pennsylvania. I've been here a couple years in the Department of Communication Arts and Sciences. I'm also affiliate with political science and am director of the Democracy Institute here.
I am Albert Dzur. I'm a professor of political science and philosophy at Bowling Green State University.
So in this vein, I wonder if I could ask you guys to address in particular Alexis de Tocqueville's celebration of the jury, because one thing that he's famous for saying is that he's not really sure about the value of the jury for the defendant. What he celebrates in the jury is the sort of participatory politics where individual ordinary citizens get to use the jury as a civic schoolhouse. And so I'm wondering, is that, if the jury is a civic schoolhouse, who's the teacher? Who are the teachers?
Well, I think,
Go ahead.
Tocqueville clearly sees the judges as the teachers. And I mean, I think you're right to say that Tocqueville does not see any direct juridical benefit to having lay people serve as jurors. I think that there's an indirect juridical benefit in the sense that by serving as jurors, actually, especially in civil cases, they come to respect the judiciary more as impartial arbiters, as experts in the law, and therefore support the legal system. That's the juridical benefit of having jurors. But Tocqueville sees the judges as the experts, the judges as the agents of socialization that teach jurors about the law and the legal system.
Yeah, I think now's a good time for me to drop in sort of my big thing on juries. So for about 10 years, I worked with colleagues on something we called the Jury and Democracy Project, and wrote a book which the publisher insisted had to be called The Jury and Democracy. Fair enough, good point. We had some ridiculous, catchy title that no one would understand. And the gist of all that research was this, that we demonstrated empirically that serving on juries actually makes many, many more jurors more civically engaged. In particular, in criminal trials, those who were previously not regular voters increased their turnout by about 5 to 7%. And that's over the course of several years. So this was actually merging real jury records with real voting histories, matching them up all across the country, and it's a pretty robust finding. It's held up in lots of respects. Two details I want to add that may figure into the conversation. One is an interesting finding that we couldn't believe, and then we replicated nationally, was the number of charges against the defendant had a sort of enhancement effect. That is, the worse trouble the defendant was in, the more the juror would probably come away more likely to vote in the future. And when we sussed that out, it doesn't look like it's the seriousness of the charges. It looks like it's the number of deliberative conclusions they had to reach. In other words, kind of the complexity of the deliberation. The other detail, and this is just hot off the presses, fresh in just to you, is Valerie Hans has been working with us on this for years, indirectly, but a few years ago she said, "You kids are crazy. There has to be an effect for civil juries, and I know you didn't find one, but give me your data." So Valerie and I have been looking at the data together, and I'll spare you the statistical details, but basically it turns out that, yeah, okay, in the aggregate there's no effect for civil juries, but when you start breaking them down, you start to see that it's the variations in the civil juries that are important. In particular, juries that have to reach a unanimous decision are more likely to have the civic benefit, and that way they're like a criminal trial, right? Interestingly, though, another key factor is if the defendant is, at least in part, an organization. Albert was mentioning before about civil juries and the role of the nonpartisan judge. Well, civil juries have the potential to be more explicitly kind of political and public, in that they don't involve an individual, they involve some corporation or entity or agency or something. And when they do, they're more likely to have that civic effect. So again, Tocqueville, it looks like, was right to some degree, that the civic jury can have this kind of civic educational effect. I would only disagree on who the teacher is. I think in the fullness of time we can see that the teacher it's a complex collaboratory. You know, that the judge is a key player, and we actually have evidence that what the judge says matters. But the attorneys and everything, they're a part of it too, and the jurors actually come away with surprisingly more respect for attorneys in many cases.
Yeah, I think that John's research actually takes us a little bit away from Tocqueville and towards what the deliberative process contributes and what the layperson within the deliberative process contributes. So for Tocqueville, the learning was all, you know, one direction, you know, from the judge down. He doesn't mention deliberation at all. He doesn't mention any of the deliberative norms that constrain debate within the courtroom. And those are things that I think really do help jurors get it right, or do the best kind of decision making they can. But I think the fact that Tocqueville doesn't talk about them says something about his analysis, which I think is one-sided. That the judge is the law expert. The lay person learns the law from the judge. And that's actually very different than the 18th century sort of revolutionary American view of the juror, who is a rights bearer and a protector of the rights of others against elites, against threats from elites, including judges. So that sort of old line about both the normative and the political authority of jurors is missing from Tocqueville's analysis. And I think it's important to bring that back in some form or another and think about the justice system as one that's not delivered by experts, but that's really a collaboration between experts and lay people.
So how can we restore juries, especially criminal juries, to the heart of our civic life? If they're even better than Tocqueville thought. You know, if it's like we learned that 2 glasses of wine every night doesn't just enhance your cardiovascular health, but also adds years to your life. Shouldn't we do more of this? How can we?
Yeah, I think that's a really big question. I mean, I think that there's sort of two parts to an answer, at least 2 parts. Okay, so one part of the answer is stopping the bypass of the jury. Okay, by limiting what prosecutors can do. This is why it always agitates me when people talk about jury nullification, because the real problem of discretionary authority is in the hands of the American prosecutor. You know, so and nobody even examines it. It's not a topic for debate. How much power should a prosecutor have? We just sort of assume that it's a good thing. So that's one issue is working on that kind of prosecutorial bypass and figuring out a way of sending more cases to trial. The other issue is cost, because if you talk to legal professionals about why there are not more jury trials, it's expense. They talk about money. It's more time consuming. It's more costly in terms of other sorts of court resources, and we can't afford it. So I think some argument needs to be made about short-term versus long-term costs. I mean, I don't think we've had a public discussion, an open public discussion in American academics, broadly speaking, outside of criminal justice circles, on the problems of mass incarceration, both normatively, politically, socially, and economically. I think we have not even begun to have that conversation. And so that needs to get started for us to be able to see the massive long-term costs on all those fronts: political, social, economic, normative, of mass incarceration. Before that happens, I don't think that we have a chance in bringing juries back or bringing more participatory control over the legal system back. And I'm hoping that this conversation is sort of part, the discussion at Tufts. Argue amongst yourselves, but just start talking about it.
So, John, you had a concrete example.
Actually, I was going to ask Albert to elaborate on the discretionary power of the prosecutor. I assume this is related to plea bargaining and a few other things, but if there's anything you wanted to underscore, I think some of the folks hearing this may not know exactly what you mean.
Yeah, that's essentially what I mean. Right. The power of the prosecutor to add or subtract charges in order to induce a defendant to take a plea. Yeah.
So I'll add a note on the criminal trial, and then I'm actually going to shift us over to the civil trial, which has disappeared at an even greater rate, actually.
You're right, yeah.
At least it's at a lower percentage. We won't get into rate. But the note on the criminal trial is this, again, it's amazing how the public can misunderstand what a jury trial is. When people get called for jury service, they're terrified. Look, chances are you're going to be out of here in 2 to 3 days, week at the tops. Right? If you get on a jury, you'll probably be done by Friday. Just an overwhelmingly high percentage of the cases are relatively quick and easy. Now, when we move over to the civil trial, then the hands go way up in the air. No, this is going to take months. They get discovery, and oh my gosh. Well, it doesn't have to be that way. In some of the most complex cases, Enron, right? It's going to take a while, folks. You buckle down because you're going to be here at the hotel. But in general, automobile, liability, some contract cases, and so on, they all can move relatively quickly. And again, referring again to Judge Dwyer and his book, In the Hands of the People, it doesn't have to be as slow as it is, right? Some of that's the judge's fault, long before the trial ever began, let alone during the trial. Now, when we go to the civil, there is an opportunity that I think there could be a criminal analog, but it's a little more complicated in the case of criminal, because you're talking about someone's freedom. But in the case of civil trials, they have started experimenting more and more in a few different states with summary and expedited trials. These are relatively quick trials. Basically, both sides say, you know what, this could drag out for months, with or without a jury. What do you say, Tuesday, we have a jury come in and we just go to town.
Right.
And, Tuesday it happens, Thursday it's done, and the case is done. It's over. And there's happiness on both sides. It's almost like kind of a mediation, except they don't trust the mediator. So I think there is a potential kind of backdoor for the jury to come in the name of expediency. My cautionary note on that is this. Remember the research we're doing with Valerie Hans right now on the civil jury. Well, the unanimous decision rule helps you get the civic benefit. To a lesser extent, the size of the jury may matter. So the Zimmerman 6-person trial was a shock to a lot of people. But in civil cases, that's very common to have fewer than 12 people. So shrinking the jury, making its decisions a little more majoritarian, robbing it of some of its sort of grandeur, could actually dampen its civic effect. So I offer you the solution in one hand and take away one of the benefits in the other. It's a research question, and I encourage anyone watching this to think about getting involved in this research. But it's exciting to think there might be a way to bring the jury back.
Mm-hmm. Yeah, I'd also point to the increased interest in informal jury-like bodies all over the place.
Yes.
So restorative justice bodies in criminal justice would be an example of jury-like things. Citizens juries. John's done some work in Oregon on citizens juries, deliberative polls. All these devices, have a kind of at least academic support and academic momentum behind them. So I think the jury idea is alive and well. It's how you get it, to how to fuel it in the old institutions. That I think is my big question right now and interest at the moment. That's trickier, I think.
And a quick international note, we've been focusing on the U.S., that's what we focus on in our work, but the reason I ridiculously hung the Australian flag behind me, which we used to wave for Lauren Jackson, the women's basketball player in Seattle, injured out this season, very sad, is I'm a huge Australia-phile, and Australia has been crazy for deliberative democracy. they do have a very active and viable jury system as well, not coincidentally. And I think the jury secures a meaning of deliberation in the public's mind that makes something like an Australian citizens' parliament kind of intuitive. Oh, it's kind of like a big jury, a little bit like a legislature, but also a lot like a jury, which is really so. It's serving this valuable function. And the funny thing is, even down at a clip of 1 or 2% of all cases, it's actually a ton of juries taking place, and they're very much in the public's mind. They're even on television in various ways now and again, though usually in a goofy characterization, but they remind us of deliberation. So there's something to be said for that.
Yeah.
So let me ask, Australia is one example, but especially in the U.S., where do you see real progress on juries? Where do you, what are the most fruitful avenues? Especially, and I want to come back to Albert's point, the role of juries in perhaps helping us to address mass incarceration. Michelle Alexander had an op-ed in the New York Times last year arguing that that criminal defendants ought to crash the criminal justice system. Every one of them should demand a jury trial. So we should go from 2% jury trials to 100% jury trials. And she believes that would help reduce the racialization of the prison population. But even if it didn't, it would at least crowd in the civic participation that juries allow. Suddenly, many, many more of us would be called to jury duty. We'd have to be. So what do you? That's one possibility. What do you think of that?
Correct me if I have this history wrong, but I just want to make a plea for the kind of sort of selective insanity of the status quo as far as jury nullification. I'm absolutely in love with this Supreme Court decision, which by all objective accounts must seem crazy. Again, if I have it right, a little over a century ago, the Supreme Court said, okay, so we understand that these juries kind of just decide what they want to decide, and we tell them the law, we tell them the facts, and then they just go make a decision. They seem to believe that they can always just make independent judgments about what's right and wrong without regard to the law, and that needs to stop. So here's the deal the Supreme Court struck. Juries can ignore the law as long as they don't know that they can ignore the law. In other words, we set it up so the jury can only acquit a Kevorkian if it so offends their conscience to enforce the law that they, thinking that they may have in fact been doing something possibly illegal or at least dicey, go ahead and acquit him anyway. As soon as somebody in the room says, "Oh yeah, you know what? You guys don't have to obey the," well, that's a mistrial, right? As soon as the jury is fully informed, it's over. Albert, did I get that right?
I think that that's an accurate characterization of how judges see nullification. Yeah,
right.
in that particular case. But I think there's something odd about seeing the law as something that is easily detected with the right sort of expert knowledge, and then can be applied in the right way by someone with the right training. The law, it's not like that. The law is kind of organic, very discretionary thing. It starts with the police officer choosing to pursue this person as opposed to that person, and to file this kind of charge as opposed to that charge, and the prosecutor and the prosecutor's team doing this rather than that, and then moving it up to the court level. And in the court process, some things come into the trial and some things don't. So I guess I would just like to get rid of the idea that the jury is doing something special and weird when it's taking a look at the applicability of the law that's under discussion in a particular case. I think that's what's been happening from the very moment somebody's become a suspect.
Sure, I'm with you. I think that's a fair point, that the latitude the jury has only is at a far extreme when we're getting in the territory of nullification, and they're consciously saying this law is unjust and we will ignore it. Right? There's all this interpretation. Here I want to emphasize that as we move toward, I'll say, a higher percentage of trials ending in juries, we actually don't have to get that high for the jury to become, in your metaphor of the Senate and the House, to become a more powerful body, possibly than the Senate itself. And here's the reason why. When the prosecutors are exercising all that power during plea bargaining, if there's a halfway decent defense attorney, they're talking about what the jury will do. And as soon as a few juries start saying, you know, this stand your ground thing, they didn't say anything about the aggressor maybe disqualifying themselves as being entitled to self-defense, but that just makes good sense. You know, the defense is going to start saying, you know what, that's how juries view it. And we have enough juries, we know that. That already happens even with the few juries we have. In civil cases, you know, the juries are just a sliver, but they are coming into every conversation about what will happen if you go to trial. So I think people underappreciate how powerful the juries are. They're even exercising power on a whole jurisdiction or a whole professional community, even from trials that you've never heard of. Trust me, the attorneys know about them. They have to know about them.
Do you have any questions that you'd like to get the group thinking about? They won't have the opportunity to question you. So why don't we reverse the traditional course?
I'll throw out kind of a broad question, which is, it would be good to have the participants reflect on if any have had jury experience. They may not have. But what are the responsibilities of a juror? What are you supposed to do as a juror? And I think, as Albert has underscored, this isn't a straightforward question. It's not a test question. I don't want to say any more to lead you down a particular path, but I think that's a good question. What is the responsibility of a juror? Or if you think of the wider deliberative activities that Albert and I have been alluding to, the same question applies there. I think it's just more interesting in the jury context because here we have an institutionalized body with a history, and yet we can still ask the question, what exactly is your role?
Mm-hmm.
Albert?
Well, I guess I'd leave people with a sort of provocative claim, okay? And that's the claim that our criminal justice system is built on a failed sociological assumption that crimes are discrete acts done by criminals who are best dealt with by legal professionals, whose job it is to contain crime through punishment and fear of punishment. To me, the jury idea says we are all responsible for crime and our responses to crime. So how is it that we are so irresponsible today, such that only 1% to 3% of our criminal cases are being dealt with by us? How have we shifted this burden? And what could we do to take some of that burden back so that we can acknowledge the amount of punishment that we're delivering on a daily basis? It's a big question.